The crime of child endangerment under California Penal Code 273A, it can be a very confusing crime, a very confusing statute. The law itself covers a very broad range of conduct and behavior. Someone can commit this crime of child endangerment in a number of different ways. The prosecutors are given quite a range of freedom when they consider whether or not to file charges under this statute. Child endangerment, in a nutshell, basically says it is a crime to put a child in harm's way or to harm a child. Now that's different than child abuse. Those are two different crimes. Child abuse is typically charged when you actually harm a child by touching the child, such as by spanking or some other form of child discipline. Child endangerment, on the other hand, can be charged in pretty much any other factual scenario you can think of. But the classic scenario, just to give you an example, is when there are young children at home and the parents are also at home, and the parents are so intoxicated or wasted, if you will, under the influence of drugs or alcohol that they are no longer able to care responsibly for their young children. There may be syringes laying around the house or drugs or other harmful substances. And in this scenario, you can see how a young child left alone and unsupervised could be in a harmful situation. So in that scenario, the parents could be facing child endangerment charges. Another typical scenario is if you were to drive under the influence of alcohol and you have a child in the car. You could see how prosecutors would think that, well, the child is in harm's way and you put the child in harm's way, therefore you could be facing child endangerment charges in addition to the normal DUI charges.